was he makes a distinction between enabling profession and disabling professions. And he said the real trick or real transformation lies in making the disabled profession into an enabling profession. I think enabling unit is a very good phrase, which one must look at elect for characteristics of one or the other, disabling and enabling person. But how to how to enable is a very serious question in literature of not of law. Of course, some people say you can never give more skills, you can never and by clinical legal education or by going by outreach programs. That's a matter of curricular change, and Alka and many friends know more about it now than I do. But I think uh, a few home truths which you all know about uh, the subject and discussion. I've read a lot. These are very common facts known to all of you, and there's no use taking your time on it. The fact is that our commonplace about our constitution is that it is not disability friendly in its origins. Our constitution had no makers had no concept in mind called disability. The concept of disability, whether in the UN Convention or the Disabilities Act, here, right, disabled people having rights, here, people living with disability, I'll simply call it PLD, the UN word. PLD, there is no notion of disability as far as I know. There was no debate, no inclusive debate, no debate whatsoever, perhaps, about disability in the Constitution. In its origin, it was somewhat gender friendly, but only somewhat. And there's no discussion of ecology or environment in the beginning. There was no doubt discussion about SC and ST and OBC reservations, which now become Article 14 and 15 and 16 and so on. But even the policy of reservation and other backward classes does not include any thought about PLDs, people living with disabilities. So it is itself a disabled constitution in some respects, in its origins. And that disability was slightly addressed by the UN Convention on the Rights of Persons with Disability Act, which is called in literature as CRPD. India ratified CRPD, and we had a Disabilities Act in 2016. And then we had a subsequent legislation called the Mental Health Act, which is very prolix. It's about 101 sections or more. And some judicial interpretation of that act has happened. So these are subsequent developments. From 1950 to 2016, disability was not highlighted by anyone. As the dean of the law faculty, way back before you maybe most of you were born in 74, 77, I was I a visually challenged person, impaired person as my student, and one paraplegic student as well in jurisprudence classes. Now, a paraplegic person could not climb two floors, and there was no lift. Alka, I don't know if there's a lift. You have a lift in Center 1, but I don't know whether the law faculty has it.
No, sir. No, sir. We've tried our level best to have a lift, but somehow have not been successful.
I used to tell a guy to stay in the near where Gandhi statue, still there? Little Gandhi in the gardens of law school, this statue. The bust was large, the figure was very small. And near the small Gandhi, we we regularly shrink him, no? We shrink him, so it must have been vanished now almost. Not, must have been, might have remained. Or maybe removed from the faculty, I don't know. But there is Gandhi statue in some way in the law faculty garden. I used to ask him to stay there. And after I'd done my class, useful class for the other people on the second floor, I came down and talked with him about what I talked in the class. So that way I couldn't myself succeed in making a lift. I made a number of suggestions, but it never worked. The engineering department. And of course, when I was the vice chancellor of the university, it would be regarded rank interference for me to do anything. Although I did many other things like the Bay Library and all that. But anyway, that was one instance. The second instance was very poignant. So, Carlis was a student who was making agarbatis, agarbatis, incense for God. His name was Dixit. He was a very bad student. He could come to the classes, but one of his friends was visually also impaired, and he was detained by the Controller of Examinations in Delhi University, Mr. Madan Mohan. And I went to Madan Mohan's office. I used to have a pre-ambulatory, so I could go, I could walk. I said, Madanji, what is this? This how have I? He said, sir, we have put a notice board. But I said, supposing I cannot see, did you put notice board in my language? I'm visually impaired, or I'm deaf and dumb. I can see, but I cannot be heard. I cannot write. I cannot speak. Am I not entitled to the same facilities? And then a penny dropped, and then he was admitted with some good effect, and he passed, and he's a friend of mine all these years. That's another matter. I didn't know nothing special at all. I just administered the place, but my concept of administration then was inclusive, to be fair to everyone, and to be unfair to no one. And I hope that concept still prevails, that administration, good or bad, it is the real task of administrator to look after all people, not some chosen people. And what happens in society is we look after some, we are told from the beginning, look after the chosen people and neglect the unchosen people. But the idea of co-citizen requires the idea of equality of all persons and equal dignity of all persons. And we had the right to equality. I can tell you many other things, but I won't take your time. The paraplegic, there was a student with cerebral palsy. He somehow made the student from North Delhi. He wanted to take examination at college of Delhi University. He was a brilliant student. He had made up to BSc or something in a good college. He was admitted, but he wanted amanuensis, writer. He could not write himself. Palsy, cerebral palsy. Uh, and he then um, approached me from heard about my activist frame, and I asked the principal. I said, "Why did you provide? What about our standards, educational standards? Supposing copies, supposing administrators from mathematics can hear all kinds of uh, all kinds of things and prejudices." I said that's a valid concern, but not a valid concern enough to prevent a student from taking examinations by refusing an amanuensis of his choice. You can grill that writer, you can make sure the writer is not from the same field, and so on and so on. Cut it down very short, he was ultimately admitted. So I have worked very closely with all kinds of all students at the equal level of dignity, but there was no CRPD then. There was no Disabilities Act came in 2000. Until 2016, it was somewhat difficult. These are watershed events. 2016, um, the ratification of the Convention, the Disabilities Act, the appointment of a Disabilities Commissioner. I'm sure you are familiar with all that, or not. If not, you should be ashamed of yourself. You should read it up. I've sent to the full article, but she probably didn't receive it. Um, I don't know now that I was the only human being with a difficulty with stringed emails. Email, I reply to one email, to another email, all that string. I get lost in that forest myself. So I have a disability myself of not being able to understand what is it, what comes first, what comes next. Neha has a similar disability, I think. I sent an article, which is still there, which is a short introduction of 5 pages to Sanjay Jain's recent book on Constitution Law of India, the Marchand
Sir, I
Review.
have shared. Sorry to interrupt you. I have shared with my students that PDF.
You have? Oh, very good. Right? My work is listened. Thank you very much. Neha. So essentially, these are the developments, and we are satisfied with the activist judiciary um, and the High Courts and the Supreme Court, which somebody has studied 28 cases, Australia, and I've got that in my introduction. So 28 cases, and she has found that in all these cases, the convention and the act made a difference. So that's the. But it's amazing, isn't it, that real concern with disability in the law in court begins with the UN Convention on Disability. We somehow left the matter to religion or civil society or to education. But essentially, the point is the question is this one this question: why, in the first place, were we not aware of this problem? Why did the Constitution and the court did not address this problem earlier, even if it was not explicitly there in the Constitution? As law students, we need to study this problem of why. And one answer is provided by disability studies. They come in two varieties. One is simple disability studies, and other is critical disability studies, or social disability studies. Either way, if you take a simple disability studies or critical disability studies, the answer and the answer of persons who are living with disability, their answer is only one, and it is called ableism. Our society is suffused with ableism. Our society does not see disability as a problem. It's amazing, but true. The example of lift still not being there in the faculty. How would I climb if I cannot climb? How would I attend classes? How would I get my attendance? Would I deny? Would I be denied access to equal facilities to study or to practice or to be a doctor or do anything I want to? Would I be denied? And this, I think, is terribly important. What does ableism say? Now, both India, the last, but one article, I think the last article by Satish Deshpande, a visually impaired scholar, was about this very problem in Nagpur Natural Law School Journal. I think it's by Satish Deshpande and Varsha Deshpande. Article on ableism, which I recommend that you read, you find time to read. Um, and there are other people like the whole books, like Fiona Kumari Campbell. Fiona writes on a book called The Contours of Ableism, the production of disability, production of disability. Disability is not, of course, one can't see, one can't hear, one can't do many things, is a fact of life. But disability is a social construction. And this particular type of social construction is where you don't see what you should see the difference, or you delegate the difference. Ableism consists in delegation, that is patronizing this difference or marginalizing the difference, or condemning the difference. It's your own what is called fate. You must have committed lots of sins in the past, but you have one disciple now as a way of punishment. So pedagogic ableism. Ableism that relies on religion to say that your past karma is responsible for and you are paying for it. And it will be a sin to interfere with your condition because you're discharging the debt to the Almighty. Now, if such is the idea, I don't know. And this is a seminar on religion, only on law, so I'll take to that. But you will find in all religions a certain indifference towards disability. You'll find in humanities, in literature, and philosophy. You will find them in legal studies. You'll find them in sports. You'll find that in administration. You just ask questions like how many disabled philosophers do you have? How many scholars in law, jurisprudence we have produced who are disabled? Now, or if they are there, we don't see them. Why don't we see them? How many teachers themselves are disabled? How many gods in Hindu pantheon are disabled? Find out and answer those questions. I won't tell you. I visited one temple. But our pantheon is also able-bodied. So the idea of ableness, again, a normal body against idea of abnormal body, which is a product of past karmas or whatever, or is accident or fortune or whatever, secular, or it is your problem, not mine. That's ableism, very crudely put, that ideology of ableism, which takes such deep roots that we don't see that disability where it exists. I was personally active during COVID times. I'm always active for one thing or another. But I read the Epidemic Act. I read the Disaster Management Act. I read various statutes. The courts have done wonderful work. 18 high courts have written on this during COVID. Have done wonderful work for COVID patients. And Justice Padma of Gujarat High Court then, as his lordship was, one went several miles further than his colleagues in other courts in asking private hospitals to open up beds, 100 beds for COVID patients. Normally, it's not a private hospital, it's a private hospital. You can't, the fundamental right to do trade and business, and you can't consider it a reasonable restriction to take certain kinds of patients. But during the COVID time, the judiciary was very active and did help people. So, in that time, however, I found that just no one worried about the disabled people. What do they do in the times of pandemic? The question was not even raised in Indian literature. But take the case of a visually impaired person. And I worked with the National Association of Blind for long years. Take the case of a visually impaired person and take the Academic Act, which says um, COVID appropriate behavior you must practice. Wear a mask, no gaj ki duri, you have to observe distance. A visually impaired person has to shop, has to socialize, has to go to market, supposing he is alone, he or she is alone. There are no trained dogs which are trained specially for pandemic. The only sense of a visually impaired person can make of the objects in the world is by touching them, sense of touch. It's very important because I cannot see. So I rely on, I touch surfaces, I touch people, I touch a stick, I touch my dog. The world is made not of objects that you can see, but objects that you can feel by touching. That's the elementary fact about people living with visual impairment. And it's common sensical observation that I'm making. Though with Kiduri was violated by every blind person in India, the world. So by definition, you cannot go to outside world without touching objects, whatever they may be, and touching other human beings. And yet they were, in a large number of cases, they were arrested for violating the rules and regulations, health regulations, and rules and norms of COVID appropriate behavior. And many of them landed in custodial detention. If they had not COVID, they got COVID. The limited operation one could do at that time, in COVID times, activism also had a backseat, although you had courts and some kind of access reform. But the point I'm making, I don't know about the whole situation. The point was an epidemic was harsher for people living with disabilities. And you one erected norms only by able-bodied person, by ableism culture in view. My point was how far the ableism disease, as it were, disability by itself, but not recognized as such, prevails in administration of law, in enforcement of law, in interpretation of law, and in exceptional times like COVID 2019 onwards. So I think there's not much to on it, but I think one has to examine that carefully in retrospect. Want to see how the world fared. I think this is not the peculiar Indian story. This happened in England, this happened in US. Where it happened, it happened. Why did it happen? Don't we take their votes gladly? Don't we take them to uh, various places where we want them to? Some play music. Don't we take them to musical halls and don't we patronize or condescend to them? Of course we do, and we call it care. We call it balad, aid. Don't we do? We do. If the artists come who are disabled, people with disabilities, we welcome them. We don't ableism, but it's not an exception to ableism. It's an expression of ableism. One which patronizes and condescends, marginalizes the agency of the other. In my paper, I've discussed also the idea of soul blindness. Now, soul blindness is a very important expressing the dialectic of blindness and insight. I will not go there. I know this is of that, but literary critic Paul de Man in Yale, professor, um, he was a professor of Yale Humanities, literature, and human sciences. He first wrote about soul blindness. He wrote about dialectics of insight and dialectics of seeing, dialectics of insight and dialectics of what's the other word I forget now. But you know, dialect of visuality, not visuality, dialect of visuality and insight in both ways. But essentially, isn't it a form of injustice? That's the question one has to raise in law school. You to marginalize, and I'm talking about not the state marginalization only. I'm talking about civil society also marginalized. So disease of ableism, considered as soul blindness, is widespread, diffused in civil society as well as the state. And it is very deep rooted. Where you soul blindness occurs, when the Wittgenstein, the famous linguistic philosopher, spoke of soul blindness as a situation where you don't recognize the humanity of the other person. That's what Wittgenstein noticed. Where you don't notice, you see, but you don't notice an aspect. He called it aspect blindness. Great linguistic philosopher. His aphorisms are worth reading. And then Cavell, Professor Stanley Cavell of Harvard, meditating on Wittgenstein, said that what Wittgenstein was trying to say was um, the idea that one does not cannot see the human being in another person. That's the real disability. But ableism converts into virtue. As the whole movement of defunding the police after the police set on a state, the Black Lives Matter movement, you know, in America, that's last year. There is a movement for a politics of soul doning. How does, how to make people see, how to make people feel the other as a human being. One lives in with others as a human being in society. How does one see it? How to evoke the multitude of difference and spurn the logic of the sameness, spurn the logic, the Vinas, the great philosopher, the Jewish philosopher, put it as imperialism of the same, imperialism of the same, which refuses to difference. how to enable the this species, that's all of humanity, this species called ableist species, how to enable them to see other human beings as human beings, other human beings as citizens, how to enable them to see them as co-citizens with rights, equal rights that you have. That's the big problem. I won't talk about intersectionality. That was my third area because I've already exceeded my time, but I will talk if you're interested about it, if you have comments and so on. I'll stop here for the time being and come to your questions and comments. Please speak loudly because I don't know how to operate the chat box. I'm a novice in this whole business of digitalization. Or somebody should please tell me. But they address me directly and speak in a way in which I could hear. Okay, thank you.
Hello, sir.
Yeah, hello.
Sir, I had a question that you basically talked about how to enable. And one thing that I have observed is through infrastructural upgrades. If there's any infrastructural change in a building, then I believe that creates a lot of change. So, in a building such as Campus Law Center, how do you believe something such as uh, such something of such large scale can be implemented?
You know, you're right. Access infrastructure is a very important idea. Access to both superstructure and infrastructure in law is a very big thing. Access to Supreme Court is very highly limited, whether by way of fees or by way of other things. Hiring a senior lawyer or getting your case to be heard in time, and so on. So normative access to norms of law and judgment, access to interpretation, although declared by Supreme Court a fundamental right, is not available. I always say, that oxymoron like oxymoron. Oxymoron, you contradict yourself, the meaningless statement. Oxymoron in my word, like oxymoron. Oxymoron, I always say, one of the oxymorons, there are plenty of them, is that in India there are two kinds of people. Those who go to court and those who are taken to courts. And those who are taken to court by far stretch exceed those who willingly go to court at any given time. So, coming to your question, under the Disabilities Act, it is an offense not to provide access for people living with disabilities. And particularly new structures that are constructed are access oriented. You are not given permission to build it. Old structures, there is a officer, a chair called Disabilities Commissioner. There is a whole Disabilities Commission appointed by Government of India and by the state, various states, in which uh, gradual upgradation within a particular given time of certain buildings which are old is overdue and is verified. The provision of ramps. I myself, uh, he said about my pipe constantly. Now I walk with my present symbol is a stick, not the pipe. I walk with a stick. So very often, recently I went to Indian Law Institute to speak at a seminar, and on 25th, on the 50th anniversary Golden Jubilee of Keshwan Bharti. I hope you are celebrating it at Delhi University. 24th of April, 50 years ago, this judgment was delivered. It's not a judgment. It is the Constitution of India. I said in 74, I wrote in a published article. that Keshwana Bharti is the Constitution of India for future. And I'm not in the business of prophecy, but I came out with true, correct in that particular. uh, So it is very important. I found, Director Manoj Sinha told me, Bhakti sir, we are very happy to have you. We are very well, but it will take some time climbing up little step. He said, no, every time they had put on a ramp, but the ramp was so rickety and there was no bar. I said, how can I use the ramp? I need some help to climb the stairs because of various physical problems. So he said, this time, the Bhakti sir, we fixed the ramp and the bar. Rooted very well, now you try it. And I was able to try it. I was very happy I could access it. So, the consciousness, the Disabilities Commissioner can take penal action and threaten to take penal action if you don't. But essentially, it is in the case, I don't go into administration of a particular place in their university. I can't do it. Given now, there 25 years ago, I did succeed, so I can understand. But I think time has long passed to make excuses. So old buildings should be access friendly, have to be access friendly under the law. And you've seen various changes in legal education, that it should be full time, that it should be a certain age restrictions. They're enforcing the law, Bar Council of India. So why can't this law be enforced properly? I don't understand. I'm not saying anything about law schools in Delhi, but everywhere. It should be, it's the minimum requirement now of the constitutional law of India that all buildings should be, all infrastructure, not just building, library inside, how it is, everybody, everything, and minimum amount is required is a ramp, requirement of ramp, and requirement of a lift is the minimum avoidance of stairs. People, so-called other people can use it, but you must provide for people other who need it. So access is a complete must. I'm sorry it took long, but that's short. I should give a short answer.
It's okay, sir. Thank you so much for this insightful session, sir. And is there any more questions? Moving on.
Sir,
Yeah. They follow up on this. First direct. Do you know who is director of the Disabilities Commission? First director, I'll tell you later on to find out. You are now all mouse. I coined the phrase the other day in my lecture in Chennai. That we are all half machine, half human beings. We cannot tick, 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 and so one mouse click jurisprudence is my new exception. So please, I appeal to you to use the mouse to find out how many elections, how many disability commissioners we have. I tell you the first one, Omar Tuli was the first person. And Padma has done a study of Omar Tuli and a biography by Prema Baxi. Was that part? We've been living close by and Kakardoba, where it's in a special uh, center where 50% of so-called able-bodied students and 50% of so-called people living with deafness study together. Therefore, there's a kind of what she calls inclusive education, inclusive learning. That from the first standard to essays produce IAS, IPS, other officials, our center. And Also, so she was the first commissioner of disability commissioner of India for 5 years. So inclusive education is built into the idea of enablement. I can try some tests if you want some, but I don't know. I don't think I can. I found it somewhere. Found it. It doesn't say anything. Are there any comments or questions? There must be because I have cut off from my presentation for hearing you.
Sir, I have a question.
Yeah,
Neha this side. Sir,
Nanya.
is Constitution silent on disability?
Pardon me?
Is Constitution silent on disability?
Yes, of course, without doubt. It was. It was. It is,
Like Article 15 is not having reference of disability, Article 16 is having no reference of disability. It is only DPSP who is little bit talk about the disability.
no, I think I discovered long ago that Article 15 was silent on disability. I always said that I had set up a committee. Um, Delhi University at that time produced doctorates in Sanskrit and other areas of visually impaired people. But when it came to jobs, they say, no, because you can't handle this overload. Although they were equal like anybody else, I learned a lot from them. Um, Anybody with um, any disability was not taken by principals of college as a teacher, although or recommended by head of department of the university and guide of the university for the job. They preferred able-bodied people. So I said, why do you do that? So Delhi University was the first to introduce a system preservations 3% for disabled. This was then followed by Government of India. So we should take some. I hope they took some pride in this fact in the 100th anniversary. I don't know. I was not invited to any occasion or they asked for invitation. But fact is, the university in our time did continue with this problem. And you know what? The entire National Revolution of the Blind protested at the Vice Chancellor's office. And the Vice Chancellor asked them, why do they do it? And they said, this is not sufficient reservation. There is a sense of outrage at the quantum of reservation. But that's all I can do. I could have done in that short time. I was in position to set up a committee and get it done. They wanted, as the alternative, all of 3% for visually disabled. It was not possible. I said, you must respect differences among yourselves. There are different kinds of disability. This was much before the convention of the UN already, in 2004. No, earlier, 90s, late 90s, and early 2000. So, cut a long story short, I think the Constitution still does not recognize among backward classes, educationally and socially and educationally backward classes of people, does not recognize disability as a ground for reservations. We started it in a small way, in our own way. We read the article. It's an accident that the vice chancellor was law faculty. so they could read the Constitution more meaningfully, or more greater access to constitutional riches, or lack of it, as it turned out to be in this case. So I don't see why, how can you say Article 14, the badge of equality, the soul of the Constitution, is switched off totally when it comes to 16.6 or 16.5. I can't see that. Article 16 is only elaboration of the complex concept of equality. Article 17 is a part of abolition of untouchability. Untouchables are saying if you converted to Christianity, why can't we be part of reservation? Even then we are treated as untouchables. So why can't we treat as untouchables for personal reservation? So it is for each state to decide who is socially and education backward, and no power of the earth prevents you from accepting power of ableism. You see, where you don't see the other, you don't see the disability as a social problem, but as an individual fate to marginalize the whole issue. Then, of course, there is no demand and there is no supply. The situation of zero sum game, put it an idea of game theory on it. But there it is. So, forgive me if I've always not responded to your question thoroughly but properly, um, and gone on my own memory. But yes, you're absolutely right. Uh, the Constitution does not prohibit disability to be considered as a factor for social and economic backwardness, but it does not mention that class specifically. And so many state commissions have to be set up and have been set up to determine backwardness, but they have never, ever. And I don't know, my studies don't go that far, as to whether people living with disabilities have asked for reservation rebate and the committees have said no. And that will be a judicial case over that, discourse over that. But I don't think disabled people have so many people living with disability have so many problems of negotiating life that they do not or they don't agree with, as I said, with the National Association of Blind, they don't agree. The internal differences are so heavy. I don't know what is the situation. But I don't think they have vocally articulated their case also. That's also a fact. The governments often take that as, now the structural adjustment thesis of structural adjustment was a thesis developed by Martha Nussbaum, a great philosopher scholar of law and divinity. She was at Harvard when she developed it, now she's in Chicago. And Martha, in a book in 2000 called Women and Development, developed the notion of structural adjustment, where the victim, the oppressed, adjusts, gives in to the system and accepts the limits placed by the system. The woman says, it's my duty to follow my husband or my in-laws. I do what they say. This adjusting, not out of necessity, but out of some kind of choice or negotiation. Some a notion of pativrata, people who obey their husband. So strong. Pavitrata. Women must be pure. Men might be anything, women must be pure. Obedience. Dharma is obedience. Now, these things are there. So if your culture, if your religion teaches you to subordinate and you accept it voluntarily, yes, we accept it, we can live with it. That is structural adjustment. So I don't know whether structural adjustment. I must make note of this myself because I never spoken this way or written this way. But I must find out, and you must help me do so, or you can send me your preprint when you write an article on this. Is there a structural adjustment also the part of PLD that they will not push for all rights at once? They go step by step. They first get the right to access, and that's it. And then after they get certain rights, then they ask for certain other rights. I don't know what is the strategy, what the trade-off here involved by associations of people living with disabilities. I should do some more work. But yes, at the present, till today, 75 years, Amrit Mahotsav, no? Amrit Mahotsav
Yes, sir.
has been celebrated.
Yes, sir, Amit.
We are going to go to Amrit Kal in 20, 30 years, on centenary of the Constitution, Amrit Kal. We're already
Yes,
under,
Ji.
officially under Amrit Kal. So if at the stage of Amrit Kal, we still don't have this, and there are problems. Probably 100 years, we must have a window for only 30 years to reach there. So in the 30 years, this associational demand should take shape, I believe. A reservation is not only a matter of caste, it's a matter of marginalization, disadvantage, not being seen as human beings. And without this scheduled caste scheduled tribe, reservation, which is some certain percentages, there should be more. There are some people, including justices on the Supreme Court, of say now, 2022, two judges, Justice, my Lord, Mr. Justice Padiwala and Mr. Justice Mela Trivedi, have observations in Jahni's case in 2022 saying we must reconsider the whole idea of reservations. But there is one view of reservations that we've experimented 75 years, that's enough. And many people hold this view, many organizations hold it, many political parties hold this view. That's only one side. So on that side, we're too late to begin to make this demand. On the other side, 30 years is a window that we have perhaps to make this demand. It depends on the wider politics, which I know nothing about. But I should say the legal law student that basically um, the structural adjustment here puzzles me by those who live with disability. Just as decision makers' uh, reluctance to extend Article 17, Article 16 and 14, 15 and 16 to extend these articles to include disability is also puzzling. Both are puzzling. I probably would end my life being puzzled and perplexed. You know, yeah. The future belongs to all of you.
Is there any more questions?
No comment?
Now,
Yes, good evening, sir. I have a question, sir.
Yeah.
Sir, sir, we have also Human Rights Commission. So we have uh, Disability Commission, yes or no, sir, existing or not?
Pardon me?
Hello.
Yes. मोहम्मद साहब क्या क्वेश्चन था आपका?
सर हमारे पास ह्यूमन राइट कमीशन है सर, एट नेशनल लेवल। तो डिसेबिलिटी कमीशन है ही नहीं सर हमारे।
हाँ है और बहुत काम करता है। one of the one of the very few active commissions is the Disability Commission. Since 2006, I think, or something. Much more work is being done, I think, by Disability Commission than by any other commission I know. And I must be wrong. There's a law commission, slave commission, all kinds of commissions. There's a blend of commissions, and I said omission. This, this, but there are two views on how disability commissioner is functioning. One view is that it's not functioning very well. It is functioning hegemonically. It has the same biases officers, some of them have, not its leaders, the chairperson, have are themselves are themselves steeped into ableism. Therefore, they can't possibly see the other. Another view is they're doing reasonably good work. Now, it's your choice after deep study of the Commission annual reports and Commission's work to take one. It's your privilege to take one view or the. My own view is, what I count, that it's doing good work and can do more, but it really is the more work it does, the more work will fall in its lap. So whatever work it has done will look small compared with demand. So it is doing, but there are two views. आप
Sir,
पढ़िए आप पढ़िए थोड़ा.
sir, this is Alka. I have a question
Yeah.
on a very serious note, sir, and that is, how do we become mentally and intellectually abled and agile in all ages and stages like you? Please give us, the faculty and the students, the mantra to do it.
Mantra Diksha is only given by gurus. I'm not a guru. Or in Kabir's word, Had Tape Solia. You heard this great verse by Kabir. Very sufficient. He said, Had Tape Solia. I translate for those who don't know Hindi. Very unlikely, but there might be somebody who knows. I'm poorly. A minor spiritual figure called Olia. The answer is only one limit. Ada Tape Solia. Behad Tape So Pir. One is called a Pir. If you transcend two or more limits, it is a superior figure than Olia. Had Tape So Olia. Behad Tape So Pir. Had, had Anhad. Dono Tape. Waka Naam Fakir. A fakir, the highest spiritual being, is one who transcends the very idea of limit. So, uh, मन लागो मरो यार फकीरिया में जो उसको पाऊं राम भजन में etc. Whatever bhajan you get, whatever your record is. So I think there is no mantra, there is no diksha. I don't give mantra diksha to anyone. I don't know how to do it. Um, so you should ask a guru or a preceptor or somebody who is not a mere teacher of law like me. But I have always felt that one thing I must tell you, that greatest enemies to law teaching are first specialization and second uh, the idea of arrival. What is the idea of arrival? Idea of arrival is, and both are linked. Idea of a law student or law teacher. Specialization means you know less and less. You know more and more in order to know less and less. That's the mantra. That's the mantra. So you are specialist in intellectual property, specialist in cosmic law, specialist in administrative law, evidence. Where do you have the time for anything else? You don't have time because specialization function of time. My Padma took me to Chandiwala Extension, Delhi, very far off. I was living in Kakaruma in South Delhi, North, East Delhi, that very long way back, very off. To meet a swelling in my foot, I still have it. I've examined it in various places in the world, in Sydney, in Bonn, wherever I've been. She took me to modern miracle worker and a doctor. And they said, you can't. She said, so I put my feet up and the swelling comes less. I go, chalta. There's no cure for it. But I met a person who specialized. I met him. I said, sir, you are very good. Yes, I'm a polarist. I don't know what polarist was. Polarist is a foot doctor. He just come back from Harvard. He said, come to the right place. Why? I said, why right place? I know you're a specialist, that's why I come, but why right place? He said, I'm a left polarist. And you're swelling on the left foot. I really I said, but both the feet are the same. He said, no, I don't touch the right foot. You're swelling in that foot, you go to another one. I'm a left polarist. That's specialization. Narrowing down, so you don't know what the other half is. So this has never been the case for me. I've never been a specialist in any field of law.
Thank you, sir.
That is one thing. I learned law the hard way and made victimize my classes. I used to tell them that I'm victimizing you. I never taught evidence. I never even learned it. I know limitation arbitration. I know not legal history, but I had to do it. I did the text. Estate duty I taught so well that it was abolished the next year. And second, so I don't know whether the connection, but that I regard as my contribution to legal education. The law was repeated. People are verified to be I taught it, perhaps. But I think one is specialization. The um, second is the idea that you have a certain degree of justification for not working hard. My colleagues in the law faculty used to come to me. They stopped coming to me after a while. Then they came back, of course. And came, all of them came because before you were born in 70s, I was asked by many people, in Baxi, why do you work so hard? So I said, work follows you. If you do your work in your area, they would do less work. I even wrote a copyright. I said, I bet people want to know Indian view, so what I have to study it, you don't write it. So if you send out some of your sloth and stop marking copies of other universities, mark your own students, that's all right. Uh, Extra money everybody wants, but try to not do it at the cost of your thinking and writing. That's a drop me like hot potato for a while. And then they came back. Some of them came back, some of them didn't come back. So I think it's very important to drop sloth. There's a part 4.1, part 4A of the Indian Constitution. You know that fundamental duties of citizen, and one of the duties is duty to develop excellence in all walks of life. If you are a law teacher, you should be have a duty to be excellent. I've often asked, what is the opposite of excellence? And I answered my own question by saying the opposite of excellence is mediocrity. Our constitution does not allow citizens to wallow in mediocrity. They all have to be A1 in their field, personal and collective. They have to develop scientific temper. That's what Constitution, I'm not saying it, Constitution says it. They have developed spirit of critical inquiry and social reform. And they have to value the composite culture of India. This is again the Constitution, Article 51A speaking, Part 4. Of course, there are no cases, we don't read that. Part 4, only two or three cases. That's no problem, that's mine. I'm saying that